It's been over a decade since we've seen this many changes in state law affecting eviction. We've got two Senate bills that were signed into law, Senate Bill 1333 and Senate Bill 38. I'm going to talk about both of these today and what effect it has on you and your landlording business. So the Texas legislature meets every odd-numbered year and proposes changes to existing law or proposes new laws. Today we're going to cover a little bit of both, and what we've got are multiple changes to the code that affect landlord-tenant law, both in the criminal side as well as the civil side. But not all of these changes are going to take effect immediately. There are some that will take effect beginning September 1st of 2025. The others will take effect in January of 2026. But it's important for you to know the difference in both and to know how to prepare for both. So I'm going to explain all of those to you first, starting with the changes that are coming September 1, 2025. The governor signed these two bills into law at a ceremony on August 14, 2025. And the first of them, which takes effect September 1st, 2025, has to do primarily with fake leases and fake occupants. People who are scamming the system and taking possession of rental property without any kind of authority. So the basic things I'm going to cover with this new law have to do with the penalties for soliciting fake leases, the rules that landlords now have to get rid of squatters super fast, and the consequences for abusing the system. And that's just the beginning. There are 15 other updates to the law that I'm going to get to after this that won't take effect until January 1st, but you're going to want to know about them to be ready when the change in the law steps into play. So make sure you stay all the way to the end so you know exactly what to expect by the end of this year. So the first two changes have to do with an area of the law that I'm not super familiar with, but I can get the point based on what's here, and I'm going to explain why this is important later. First, we have changes to the penal code, and these changes establish that presenting a fake lease or sale documents having to do with residential real estate is itself a misdemeanor, specifically a Class A misdemeanor. This happens when someone wrongfully presents to another person a false, fraudulent, or fictitious document purporting to be a lease agreement, deed, or other instrument conveying real property. So the mere presentation of a fake document to someone else is a misdemeanor. However, the heat cranks up a little bit once the transaction is actually completed. In fact, it goes all the way to a first-degree felony. This happens when a person knowingly lists or advertises for sale, rent, or lease residential real property while knowing that the person offering to sell, rent, or lease the property does not have legal title or authority to sell, rent, or lease, or they sell, rent, or lease to another person. So listing is bad enough, but even if you don't list the property, if you follow through and have someone sign a fake lease and sell, lease, or rent residential property that doesn't belong to you, you've just committed a first-degree felony. Now, Ernie, does this mean that I have to report these people to the authorities and I have to wait for some criminal conviction before I can get any kind of relief? No. In fact, I don't know that the criminal side of this is going to be much help for you in the eviction court, but it could be a tremendous amount of help in the civil court. From time to time, we're presented with cases where a landlord has someone living on the property that they have no awareness of. They never interacted with them. The lease that they're holding was not produced by the landlord. In fact, their claim is that that lease was supplied to them by some other party who, of course, they now cannot get a hold of, but that party proposed that they had the authority and the right and title to the property to enter into this agreement and lease the property to these individuals. Now, whether that's accurate or not shouldn't prevent you as the actual legitimate owner to recover your property. But sometimes the people who are in place are so insistent that they have a legitimate right to be there that they refuse to go when they are asked. That's where the changes in the civil law come into play. Beginning September 1st, 2025, owners of residential rental property will be able to remove these unauthorized occupants without the need for an eviction at all. Now, in order to do this, you have to meet very specific criteria. You can't just go evict people through this alternative method just because you don't want to go the regular method. This only applies in very specific cases, and I want to explain how it does apply and when it does not. So the first threshold that you have to cross is you have to be the owner of residential real property, and the person who's there has to have entered unlawfully. That word is extremely important because you can't use this mechanism for anyone who had permission to enter the property, whether you gave it to them or they got it through you indirectly. For example, if someone has a guest on the property, you cannot say that that individual was not likely permitted through probably the terms of your residential lease to have a guest, and therefore have that particular person who entered into no agreement with you to stay on the property. A guest probably has just or close to as many rights as the tenant does by virtue of their lease agreement with you, the landlord. So it wouldn't apply to someone who lawfully enters the property. So one of the restrictions is the property cannot have been available to the public, open to just anybody to come in, and that's why the individual was there. If they came in on that theory, then no, you can't say they entered unlawfully. Additionally, this would not apply if you and that individual are currently in pending litigation having to do with the property. If the rights of that individual are currently being decided in some other court, you can't use this method for the quick eviction. Now, another requirement is that you've given notice to the individual for them to leave the property. How you deliver it, it's not clear. It's just stated that you must have given them notice to leave and they refused to leave. Naturally, when you don't have a contract agreement with somebody, it's going to be difficult to prove that, number one, they even had a mailbox key to go check the mail, so the mail might not be an option. Additionally, you may not be all that comfortable going into the unit, so opening the door and handing it to somebody might not be an option. But it is up to you to demonstrate to the court that they were given some notice, that you directed them to leave, and they refused to leave. One key point is that it doesn't require that notice to be in writing. So as long as you can prove that you gave this individual a requirement to leave and they refused, then you can go on. Now, as I mentioned before, this would not apply to a current or a former tenant, right? So the fact that the lease has come to an end and you believe that they no longer have a lease doesn't mean you can use the quick and easy route to get rid of this tenant. If they are a current or a former tenant, this rule would not apply. Neither does the rule apply to immediate family members. So no, you can't kick out your brother or your sister or your mom, your dad or your child. Cousins, probably. Uncles, aunts, grandma, sure, but none of your immediate family. Now, naturally, in order to request this, you have to request it from someone. The state of Texas allows you to make this request to either the sheriff or the constable in your county. If you look in the description below, you'll see a link to a form that you can use, which comes right out of the code to fill in the blanks and make your request. Now, you'll see on the form that you are required to swear to the facts that are in this document and that You make these statements under the penalty of perjury. You also agree to cover the fees. Usually the fees that are associated with a writ of possession will apply in the situation that you pay directly to the sheriff or to the constable. Once you deliver this form to the constable, they then have a set procedure established in this new law to carry out and exercise this order to remove people based on your declaration that are on your residential rental property without your authority and after you've given adequate notice. And these people do not fall into any of the exclusions that are in the law, and that you verify by swearing under oath that the facts in your form are correct. If it turns out that someone uses this new right in an abusive manner and removes somebody wrongfully, well, the code also hands down a pretty stiff penalty. Whoever is harmed by someone unlawfully having them removed can ask for not just their economic damages, they can ask for their actual damages and exemplary damages along with their court costs and reasonable and necessary attorney fees. So this is not something you should toy around with. It's not something you should use as a backdoor option to speed up the eviction process. You must be certain that all of the situations apply and that you have presented your matter to the constable or the sheriff in a proper way. Otherwise, you subject yourself to some pretty stiff penalties. The second bill has even bigger and more sweeping changes, but none of these will take effect until January 1st of 2026. I'm going to target 15 of them for you today to make sure that you are ready once this year comes to an end. So Senate Bill 38 introduces a new feature in the law that I'm going to call the one chance rule. And in the one chance rule, your tenant has the ability, when you send the very first time a notice to vacate to them for their very first non-payment offense. In this version of the law, beginning January 1st of 26, you are required to give the tenant an opportunity to pay if they were otherwise not delinquent in rent the month prior, and you've given them written notice. They have the opportunity to pay what is owed. Your notice should be given in a form that says pay rent or vacate. Therefore, if the tenant does pay, you no longer have the right to seek that eviction. If they fail to pay, as long as your notice properly gave them that option, you can proceed with your eviction. And it's up to you to understand the difference. Did you make that option available to your tenant? And if you didn't, you're not going to get your eviction. If the judge sees that you gave insufficient notice to your tenant, you could be turned around and denied the eviction. However, let's say that your tenant was in fact delinquent with their non-payment of rent from the month before, and they're delinquent again this month. Because an entire month has gone by and they have failed to pay the rent, whether you gave them notice in the first month or not, which of course I would always suggest you do. Don't let 7 days go by without giving that notice, in this case, to vacate or pay rent. If you're in the second month, you can give a straight notice to vacate. You can also give the notice to pay rent or vacate, but you're not required to if the tenant was delinquent in rent the month prior. Now, for many of you, this is going to require that your ledger is kept intact. So I get landlords that come to me with crazy facts all the time because they keep bad ledgers. Let me give you an example. They'll say, Ernie, let's assume we're in the month of September. They'll say, no, they paid August's rent, but they owe rent for the month of July, and so this rule wouldn't apply. And my obvious question is, how is it possible that they have a debt older than the last payment they made, but you're claiming they don't have a debt for the most recent month? That doesn't make any sense to me, because it is a much better practice to apply every current payment to the oldest debt first. If in this scenario, you had taken the money you received in the month of August and not applied it to August, but applied it first to the oldest debt, which in this case was July, then in fact, yes, you would have unpaid rent for the month of August. And if you are in the month of September, this rule would apply and allow you, the landlord, to issue a straight notice to vacate in the month of September to your tenant. But you have to understand the rule, and you have to understand how best to operate your rent ledger. Now, previously, you've heard me talk about how the CARES Act is still technically in place, and how some courts in Texas enforce the 30-day requirement for your notice to vacate and some do not. And this will come into play if you lease property subject to some kind of federal program and therefore receive federal funding, or if you have a loan subject to some kind of federal backing. Fannie Mae, Freddie Mac are there guaranteeing your loan. You now have to give a 30-day notice. A change in the law in the state of Texas does away with that and says that no longer applies, and so that it is crystal clear, federal law would not affect the steps that landlords would have to take in the state of Texas in order to deliver notice and demand possession. The only stipulation is that a writ of possession cannot issue within those 30 days. So that if the eviction happens so quickly that you're set to get possession back in fewer than the 30 days required by federal law, this law says you gotta wait the 30 days. But I gotta tell you, that's a pretty good problem to have. If the eviction court is working that quickly, well, it's better than things used to be. Now, this next change is one of the more exciting changes to the law because it's going to make delivery of your notice to vacate so much easier. The law continues to advocate for delivery of your notice to vacate through the mail, regular, registered, certified, but now it allows you to deliver through a delivery service. So FedEx or UPS are now perfectly acceptable methods of delivery if that is your preference, or if that's going to be the most effective way to get the notice to your tenant. Additionally, the law has gotten away from requiring that notice on the inside of the property has to be posted on the inside of the main entry door. Instead, what the law now requires is that it be placed inside the home in a, quote, conspicuous place. So it's gotta be obvious. The inside of the door is one place, but it's not the only place. So as long as it is conspicuously posted, you've met the requirement. Hand delivery is still on the table, but hand delivery is only appropriate to a tenant who is 16 years of age or older. So you got to still be able to prove that the person you handed the notice to was a tenant, not just an occupant. The law clearly says it has to be a tenant. And finally, one of the most interesting changes is that if your written lease allows for transmission and delivery of notices by email or, quote, electronic communication, including email or other electronic means, you can now deliver your notice to vacate beginning January 1st, 2026 through email. And this suggests other electronic means so long as it is part of your lease agreement. Now, this is something that I already advocate, that you have multiple mechanisms of contacting your tenants in your written lease agreements. Now, the law even allows you to deliver your notice to vacate in this way so that you can prove delivery even earlier than before. But it gets even better. A new provision in the law says that none of these methods need apply if you can prove that the tenant got actual delivery of the notice. And this happens so many times where I see tenants show up and say, yes, I got it, but it was delivered improperly under the door, or it was handed to my neighbor. Yes, I eventually got it, but it was technically incorrect. The law now says this subsection would not apply if the tenant actually receives the notice. And so now, if you actually get it, you are counted, even if the delivery method was improper. One additional exciting change in the law is one that's going to get rid of some of these delays that really just prolong eviction trials and needlessly add time and wasted money. This change has everything to do with courts no longer being allowed to force landlords and tenants to attend mediation or some kind of pre-trial conferences before they get to go to trial. The legislature clearly wants evictions sped up, and this is one definite way to do it. By eliminating this requirement, cases will get to trial much faster. Additionally, if there's some error in a petition filed by a landlord that can be corrected, the law allows the landlord to make such corrections and prevents the court from simply dismissing the case on those grounds. If the petition can be corrected, the law requires that the court allow that landlord to make that correction. The legislature was very clear that it wants evictions to go by faster. In fact, the legislature now requires that service of the eviction petition be delivered within 5 days of it being filed. Now, these are 5 business days, but still faster than many courts across the state of Texas. Additionally, the law requires that a trial not be set sooner than the 10th day after it's filed, but get this, not later than the 21st day after the date of filing. From filing to court in no more than 21 days. Additionally, while presently, depending on when you watch this video, but before January 1st of 2026, the court is required to wait at least 6 days to give 6 days of notice to a tenant before a trial can be heard. That has now been reduced to 4 days. Again, speeding up the trial, and no trial can be postponed for more than 7 days unless both parties agree. So you no longer have the court simply resetting things a couple of weeks or even an entire month just because the court feels like it. The legislature is clear, and these things must go quicker. Now, here is a monumental change to the law. While a few years ago, the legislature introduced to the Justice Court the motion for summary disposition, they haven't gone super well in the courts. I believe this change in the law is going to change that forever. And here's why. The legislature now allows a petition to be filed with a motion for summary disposition, which essentially says, Your Honor, there is nothing in dispute. There is no controverting evidence that would overcome this petition, and therefore there's really no need for a trial, so you can grant my judgment based on my sworn statement. Now, while I'm very hopeful about this as a procedure to speed up the eviction process, I'm not sure that it's going to work everywhere, mostly because the code says, quote, the court may enter judgment in favor of the landlord without trial if a motion for summary disposition is attached to their petition. So because it says the court may do it, it's implied that the court may not have to do it if the court doesn't see fit. However, here's what the rule says. Not later than the 4th day after the date the tenant is served, the tenant can file a response with supporting facts. If they do this and the Justice Court determines that service was proper and there are genuinely disputed facts, the motion is denied. The court may enter judgment if the response does not show that there is some kind of genuinely disputed fact. In other words, if everything you say is rightful and the tenant responds and doesn't really change those facts, ideally what you're talking about is non-payment of rent, and the tenant says, well, the reason I didn't pay was X, Y, or Z, which serves as no defense for non-payment of rent, then the court may issue a judgment in this case. Now, while the rule requires that the tenant respond within 4 days, even if the tenant responds after, but before the judge has signed the order, the tenant is allowed to supply evidence. And if that evidence does raise a genuine fact issue, then you're not going to get your motion for summary disposition. But this might really streamline the eviction process, particularly in those evictions where the tenant makes no response whatsoever. How many of these evictions are filed and it's just default after default after default? I believe this is going to revolutionize the way that cases are presented and the way that cases are won. It's going to reduce the size of these dockets, particularly here in Houston, that have 100 or 150 cases, many of which are just these voluminous default judgments that really get in the way of all other cases and just extend and prolong the eviction process for everybody else. By doing it this way, there's no need to rush to the courthouse or waste time showing up just to collect a default judgment when you can file your petition with a motion for summary judgment, collect your default judgment without ever having to appear in court. Here's another big change. If a tenant appeals, they have to file a sworn statement saying they've got a meritorious defense. And that statement is made under the penalty of perjury. So they have to already have a good defense. If they don't, they cannot appeal. Now, if a tenant has appealed and they have substantiated that they do have a meritorious defense, they've sworn to it on a stack of Bibles, they've got a defense, fine. They're allowed to proceed under the same rules as before. However, one difference is that we now have some uniformity in the way that a landlord can secure a writ of possession if part of the tenant's requirement is that they pay money into the court's registry. In the past, there was no regulation as to when a landlord could go in and obtain a writ of possession in this situation. Now the legislature has cleaned this up a little bit by saying that a court cannot forward the case to the county court until 4 p.m. on the day after the tenant's deadline to pay into the registry of the court their rent. Let me boil this down for you. If a tenant appeals and part of their appeal requires that they pay money into the court's registry, and they have a date certain when the money is due, their failure to pay that means you as the landlord can go the very next business day to the court and secure a writ of possession. And now the law specifically says that the court can't say at 9:30 or noon or 1 p.m., send that case downtown to the county court. Instead, the law says they must wait until at least 4 p.m. and they cannot wait longer than the 10th day before they send that case to the county court. This gives you, the landlord, at least one business day to get to the court and purchase that writ of possession from the justice of the peace. But it also informs you that the court's on a time crunch, and if you don't do it soon enough, you may lose your window. So always, always, always know what that deadline is, confirm whether or not that payment has been made, and if it hasn't been made, rush to the courthouse the very next business day, purchase your writ of possession, and recover your property faster. Another gem is that before, that quick writ of possession was only available through the justice court, but now the legislature has seen fit to include the county court in this process. Previously, a hearing would have to be set, and a motion would have to be made, and an order would have to be signed. None of that is required anymore. The legislature has said, nope, the same process that goes forward in the justice court is available in the county court. If the tenant fails to make a payment, you can simply make a request within the time frame as required under the rules. If the tenant fails to make their payment, you are eligible for, guess what? An immediate writ of possession, just like the rule says. No more delays with unnecessary hearings. As of January 1st, 2026, if the tenant fails to make their payment into the county court registry, you have just the same option as you did in the justice court when non-payment occurs. Now, not every court does their judgments in exactly the same way, but the legislature has stepped in to make sure that certain things apply in all eviction cases. One of those is the following statement: the court shall determine the amount of rent to be paid each rental period during the pendency of any appeal and shall note that amount in the judgment. This applies, quote, if the Justice Court enters judgment for the landlord in a residential eviction case. That's all of them. Guess what? It even involves cases where there was no rental agreement. In those cases, the legislature requires the court, quote, to determine the rental pay period and the amount of rent to be paid by the tenant, which must be the greater of $250 or the fair market rent. So it's pretty easy to say that at the very least, even when you have a post-foreclosure or you have a tenant at will, the landlord is still entitled to some basic recovery. If the landlord can prove, listen, I could otherwise rent this place for $1,500, but I was letting my cousin stay there for free, and I asked my cousin to leave. We never had a rental agreement, but I would like the court to establish as a part of the judgment that if they stay, they got to pay $1,500 into the court. And if the judge determines that to be a fair market value, guess what? In order for that tenant to appeal, they would likely have to pay either a cash bond or an agreement to pay monthly rent into the court registry in that precise amount, but nothing less than $250. No more free rides. Additionally, it's no longer optional in the event of an appeal, quote, if a tenant files an appeal of the Justice Court's judgment in an eviction, the Justice Court shall provide to the tenant a written notice at the time of the appeal that it's filed that contains the following information in bold or conspicuous type: the amount of rent that the tenant must pay into the Justice Court or County Court Registry as applicable during the pendency of the appeal. Now, for those of you who spent a lot of time waiting to recover the registry funds in the court's registry, no longer have to wait. The new rule says the Justice Court or County Court, as applicable, shall distribute rent paid into the Justice Court or County Court Registry to the landlord on request at any time during or after the pendency of the appeal. So if it's paid on day one, guess what? On day one, you can make a request to have those funds delivered to you. Faster, faster, faster. And so these are some of the really cool changes that are available that I strongly encourage you to take advantage of. Don't wait on the Justice Court to ship the money down to the county court and then wait on the county court to get to judgment before you get your money. At any time during the pendency of the appeal, ask immediately for those funds from the Justice Court. And if any funds are paid into the county court, ask immediately that those funds be sent directly to you. Another rule regarding the rent payable into the registry is if a faulty determination or a determination that was maybe too low was made in the Justice Court, guess what? You can ask for reconsideration from the county court to raise that amount up. I don't know how practical this is, but it is something that's available. However, it's also available in the other direction. So if the Justice Court says something too high, then the tenant could technically request from the county court that the amount be lowered. Just understand that that option is now available. Now let's say you've recovered possession because you got rid of possession, because the tenant failed to pay into the registry, or because the tenant just left. Here's what the law now says about your ability to recover a judgment for unpaid rent and attorney fees. If the Justice Court issues a writ of possession under this section, the Justice Court shall forward the transcript and original papers in the eviction case to the county court for trial de novo to resolve any remaining issues in the case, such as rent or attorney's fees, notwithstanding the fact that the writ has already been issued or executed. So whether or not the tenant is in possession, you are still entitled to obtain a judgment for unpaid rent and attorney's fees. Now here's an interesting twist on service of the writ of possession, because sometimes there's a long delay and you wish there was something you can do to speed up the process. Here is another change in the law that does just that. If the writ of possession is not served on or before the 5th business day after the date the writ is issued, the landlord may, but is not obligated to, have the writ served by any other law enforcement officer, including an off-duty officer with appropriate identification who has received training as described by section 24.0051F. Now, I'm not exactly sure where we're going to find a list of these available officers, but I have a strong feeling that once this kind of information is publicly available, then yes, landlords will be able to serve these writs in a much faster way and recover their property sooner rather than later. 10 days can make a substantial difference. If your rent is $3,000 a month, well, 10 days is a whole $1,000. And so it might make sense to hire an officer who does this kind of work. You pay an additional fee, much like your writ of possession fee, it's about $130 to $150 in order to obtain your property sooner and save yourself from additional losses. Now, the last change actually offends me a little bit, but it really doesn't. It has to do with non-lawyer representation. Now, the rule was always so confusing that even I had a hard time explaining this to clients. And so I'm not going to get into what was confusing. Instead, I'm just going to explain what the rule will say as of January 1st, 2026. For non-lawyer representation in an eviction in justice court, the parties may represent themselves or be represented by their authorized agents who need not be attorneys. Boom, pure and simple. There are no limitations. It says any party, and that includes the tenants. They don't need a lawyer to represent them. Just an authorized person who's there in their place may stand in and say, yes, I represent this party, and I'm here to stand in their place. In the justice court, it's wide open. Parties may represent themselves or be represented by their authorized agents who don't have to be attorneys. The rule's a little different on appeal. In an appeal in an eviction suit specifically for non-payment of rent in the county or district court. So this is on appeal, and it's specifically limited to non-payment of rent. An owner of a multi-family residential property may be represented by the owner's authorized agent who need not be an attorney. Once you get to the county court, that non-attorney representation essentially evaporates, except in the limited situation where you have an issue of non-payment of rent, so regular lease violations wouldn't apply. It has to be the owner of a multi-family, so we're talking apartment complexes, your triplex, your duplex, even a quadruplex wouldn't apply, and certainly individual houses would not apply. So it's gotta be non-payment of rent, residential multi-family, then an authorized agent of the owner can appear in their place without the need for an attorney. Everybody else has to have an attorney. That's commercial leases, if that's a violation, multifamily or not, of the lease that have nothing to do with rent, or if you're in a single family home, which includes, again, duplexes, triplexes, and even quadruplexes, 5 units or more is what constitutes multifamily. If you're in one of those situations, unfortunately, this rule wouldn't apply to you on appeal. In all other situations, you're going to need an attorney. And so your authorized agent, if you have one and you own residential multifamily property, can show up for you. That's usually your property manager. They can show up and handle, again, non-payment of rent cases for you in county court on appeal. And there you go. Those are a multitude of changes, most of them quite good, that are taking effect. The first few will take effect in September. The rest of these will take effect January 1st of 2026. I hope you've gotten a ton of great information out of this legislative update. If there's additional information that you're seeking to learn even more about landlording, there's a set of videos right here that YouTube seems to think are absolutely perfect for you. I welcome you to check those out, along with the rest of the stuff we have in our catalog of videos on this channel. But until next time, landlords, happy leasing.